In contracts law, the capacity to contract refers to the legal ability of a person or entity to enter into a binding contract. Certain individuals or entities may lack the capacity to contract, either due to age, mental capacity, or legal restrictions. Here are 5 fundamental features of capacity to enter into contracts under contracts law. 1. Legal age. Legal age, also known as the age of majority, is the age at which an individual is considered to have attained the legal rights and responsibilities of an adult. This age is typically set by law and varies across jurisdictions. In many countries, the legal age of majority is 18 years old, but it can be different in some places. Minors, on the other hand, are individuals who have not yet reached the legal age of majority. In general, minors are presumed to lack the full capacity to contract. If a court determines that a person lacks the mental capacity to understand the contract may be voidable or unenforceable against that person. The person may have the option to seek to set aside the contract based on their lack of capacity. Once a person reaches the age of majority, they are presumed to have the full legal capacity to enter into binding agreements. They are considered to be able to understand the nature and consequences of their contractual obligations. The age of majority, therefore, is a precondition for contracting. 2. Sound mind. The requirement of a sound mind is sometimes also referred to as mental competence or mental capacity. It pertains to the mental state of a person at the time of entering into a contract. It involves the ability to understand and appreciate the nature, terms, and consequences of the contractual agreement. To have the capacity to enter into a contract, an individual should be of a sound mental health and free from any mental illnesses or cognitive impairments that would affect their ability to comprehend the contract. Some common examples of mental conditions that may affect capacity include severe mental illnesses, intellectual disabilities, or conditions that impair cognitive functions. The concept of a sound mind serves to protect individuals from being taken advantage of when they lack the mental capacity to understand the implications of a contract. Courts may consider various factors in assessing mental capacity, such as the ability to understand the nature of the contract, appreciate the consequences of the agreement, and make rational decisions regarding the contract's terms. Medical evidence or expert testimony may be considered in evaluating a person's mental state and capacity. If a person lacks the mental competence necessary to understand the contract, they may be deemed to lack the capacity to enter into agreement. 3. No undue influence or duress. Undue influence refers to a situation where one party exerts excessive pressure or influence over another party, leading to the unfair persuasion of that party's decision-making. The key element in undue influence is the exploitation of a position of power or trust to manipulate the vulnerability of one party. When undue influence is present, it can undermine the voluntary and independent decision-making process necessary for the capacity to contract. The party being duly influenced may agree to a contract or its terms against their own best interest or without fully understanding the implications. Duress involves the use of threats, coercion, or force to compel someone to enter into a contract against their will. Duress typically involves situations where a person is coerced into a contract due to fear of harm or severe consequences. Examples of duress can include physical violence, blackmail, extortion, or threats of illegal actions. The key element is that the party's consent is obtained through fear or intimidation rather than freely given. Both undue influence and duress viewed as elements that negate the voluntary and informed consent required for a contract to be valid. Courts aim to protect parties from entering into contracts against their will or under unfair circumstances. 4. Corporate organizational capacity. The corporation is separate from its owners or members. This legal personality enables the entity to enter into contracts and engage in legal transactions in its own name. The entity's capacity to contract is determined by its legal structure and the laws that govern its formation and operation. A corporation or organization is typically formed by complying with certain legal requirements, such as registration, incorporation, or establishment according to the applicable laws. Once formed, the entity is granted certain powers and authority to conduct its business affairs, including the power to enter into contracts. Once it has met those conditions, it is said to have the capacity to enter into contracts. When a corporation or organization enters into a contract, it is binding on the entity itself, not on its individual shareholders, owners, or members. The contractual obligations and liabilities generally belong to the entity unless specific personal guarantees are given by individuals associated with the entity. In some cases, a corporation or organization may have limitations on its contractual capacity. These limitations may be imposed by law, its governing documents, or the nature of its business activities. Actions which are outside authority are said to be ultra-virus. Contracts that are ultra-virus may be considered void or unenforceable. 5. Legal restrictions on public policy. There are certain types of contracts that are prohibited by law. These contracts are considered illegal and parties lack the capacity to enter into them. For example, contracts for illegal activities such as contracts related to drug trafficking or contracts that violate public policy are generally unenforceable. The law prohibits parties from entering into contracts that are against public welfare, morality, or that contravene specific statutes or regulations. In certain industries or professions, individuals or entities may be required to obtain licenses to meet regulatory criteria to engage in specific types of contracts. Examples are doctors and lawyers. These licensing requirements may be imposed to ensure public safety, consumer protection, or professional standards. Failure to meet these requirements may limit or invalidate the capacity to contract within the regulated field. Public policy refers to the principles, values, and goals that the legal system seeks to promote in the best interests of society as a whole. Contracts that contravene public policy, such as those that promote illegal activities, harm public welfare, or undermine important societal values, may be deemed unenforceable. Courts may refuse to enforce contracts that are contrary to public policy, even if the parties involved have given their consent.
If you like the video, make sure you subscribe to the channel, hit the like button, and write your comments in the comments section below. Until the next video, we hope you have learned something useful for your education in the law.